As has already been noted, I raised concerns about an earlier version of this amendment at committee stage because I argued then that ultimately it felt like it was legitimising a climate of demonising protest based on a subjective assessment about whether those protests were politically approved of or not. Specifically, this new amendment relates to attitudes to COVID vaccines that I want to look at. But to put it beyond any doubt, I support the use of vaccines, although not vaccine passports or mandated vaccines. I'd say that too. But I don't believe that those who are opposed to vaccines, whether they're tennis players or NHS anaesthetists or fearful pregnant women or even conspiratorial cranks, I don't believe that any of those people should be criminalised or discriminated against because of their views. And I am concerned that there are aspects of that would happen from this amendment. This new amendment now expands the use of the proposed fast-track public space protection orders beyond activities outside schools to venues providing NHS vaccination service to the public. And as already been described, we all have in mind those scenes of vaccination centres that were invaded with equipment trashed, abuse shouted and so on. And as it happens, like everyone else, I condemn those, that activity. But, my Lords, if, as the amendment notes, such activities involve harassment, intimidation or impeding members of the public accessing service they want to access, or of staff or volunteers providing that service, surely we have laws on the statute book to deal with this, and those laws should be applied. My question really is, why do we need to use PSPOs? And why are they proposed for non-specified activities outside schools, which could obviously be used to, for example, prohibit anything from leafleting to collecting names on a petition for any cause? Because actually, in relation to the schools part of the amendment, anti-vaccine issues are not mentioned. I confess that I have long been an opponent of PSPOs. Sadly, I feel used as arbitrary powers issued by councils acting as though they run fiefdoms, and I've written about the issue regularly since 2014 when they were brought in council publications such as the Municipal Journal. PSPOs do not ban any particular activities, which is why they are so broadly interpreted, often depending on the pet hates of local councils. Their name is something of a misnomer because rather than protecting the public, they are mainly used to eject the public from public space, effectively privatising public space. Indeed, they are regularly used as dispersal orders for example, groups of individuals hanging around, often young people, or for political vigils or leafleters. And often they're dispersed by authorised private security guards with the power to issue on-the-spot fines, because one has to consider who would police these PSPOs in this amendment. No wonder then that the civil liberties group, the Manifesto Club, have warned that PSPOs fundamentally undermine rights of free association and free expression in the public square. Indeed, in 2017, the Home Office recognised the overuse and overreach of PSPO powers and produced amended statutory guidance, but to no discernible effect, because they are now being issued at an increased rate and rising. Now, the fast-track PSPOs proposed in this amendment have conditions, but actually those conditions simply use the phraseology usually associated with the orders in terms of activities that various individuals consider have, quote, a detrimental effect on the quality of life for the public or staff or whoever it's being discussed. It's that detrimental effect on the quality of life. That phrase, detrimental effect on the quality of life, has been critiqued by many opponents of PSPOs as very vague and elastic, and it has led councils in recent years to use PSPOs to restrict everything from cycling, charity collecting, rough sleeping, walking dogs without leads, begging and busking. And two of my favourites, a couple of dozen councils have used that phrase and PSPOs to ban swearing, and another activity deemed bannable is loitering. Now, I don't know if any of my lords have ever dropped the kids off at the school gates, but loitering in groups, often involving a little swearing, I confess, is almost a compulsory activity for parents. But more seriously, as the Manifesto Club has regularly noted, not only does the test of detrimental effect the test of detrimental effect is an unprecedentedly low legal test for criminal intervention, but there's also no requirement to show any substantial evidence of such detrimental effect. There's no proper democratic oversight locally, with no requirement for PSPOs to be passed through internal scrutiny procedures within a council. And normally, there is a requirement for consultation, but as has already been explained, this amendment dispenses with that. And even the usual consultations are usually fairly procedural, and many PSPOs have been passed with as few as 10 respondents responding. But anyway, in this instance, all that we've done is just removed even the formal need for consultation. And so, therefore, issuing the PSPO would be signed off, as we've been told, by just 3 people: the police chief officer, the school leadership, and the local authority leader. And the public would only be consulted after the order is issued, which I think is laughable and contemptuous. Also to note, there is no workable system for appealing PSPOs locally beyond an appeal to the High Court. And finally, to note the wording of the amendment, that these fast-track PSPOs can be issued for activities not just carried on, but likely to be carried on. Not that just have had a detrimental effect, but that are likely to have a detrimental effect. And I think these are weasel words, my lords, wholly open to speculation and a kind of pre-crime-like interpretation. To conclude, I would hope that those noble lords who on Monday will be opposing the swathe of legislative proposals that threaten to close down protest and chill the rights of free assembly will also oppose this amendment. I find the views of hardcore anti-vax protesters distasteful, nihilistic, absolutely things that I would argue against. I actually feel the same about Extinction Rebellion, but I think that misses the point. So I just think that we need to be very careful about picking and choosing which protesters we support or not. And if there is a problem of obstruction or any kind of unlawful activity outside schools or vaccine centres, it should be dealt with. But this amendment, I'm afraid, would give succour to the government ahead of Monday's battles, and I will therefore oppose it.